to NRA News, Cam and Company. CJ Ciaramella of the Washington Free Beacon, Dr. A.W.R. Hawkins from Breitbart News, still to come next hour. Right now, I want to welcome to the program Second Amendment attorney and scholar, Mr. Steve Halbrook. Steve, how are you, sir?
Wonderful, Cam. How are you?
I am great. Thank you so much for joining us on the program. And, boy, yesterday, a big decision in the Ninth Circuit Court of Appeals in the Peruta case. We've been waiting for this decision for a long time. Really kind of wondering when the court was going to come down with this decision, but I have to say it was well worth the wait.
It was, and it couldn't be a better opinion. It's called Peruta versus County of San Diego. California law requires you to have good cause to get a permit to carry a handgun. There's no open carry allowed at all, but it would be carrying it concealed. And there's a policy in some jurisdictions, including San Diego, that good cause does not include self-defense. It includes only if you you're in a unique situation, and it cannot be a situation where you have a constitutional right to bear arms, or that you live in a really bad neighborhood where everybody's endangered. It has to be in a situation where only you out of other people is somehow endangered. So the policy was to deny all the permits, and this court basically struck down the policy. The California statute stands and requires good cause, but you should be able to simply put down on the application that your good cause is self-defense. So it's a wonderful victory for the Second Amendment.
It absolutely is. You know, and it's interesting. We were kind of going through some of the media reaction. The San Francisco Chronicle yesterday, Steve, talked about how this was an outlier. In the Second, Third, and Fourth Circuits, they don't recognize this right. Interestingly enough, the San Francisco Chronicle did not mention the Seventh Circuit decision, which also did recognize that the right to bear arms outside of the home exists as part of the Second Amendment. And more importantly, they completely ignored the fact that the Peruta decision yesterday went into great detail about the Second, Third, and Fourth Circuit decisions and where the court thinks they got it wrong.
Well, yeah, it did what the Supreme Court did in Heller. It begins with the text and moves on to the history. And in regard to the text, it's a no-brainer. It says bear arms. The Second Amendment clearly says bear arms. It's like denying that there's a right to assemble when it's right there in the First Amendment in plain English. Or saying that only people with special needs can assemble. So we went on the text, and then on the history, the court looked at early practice from the time of the founding through the 19th century and traced the fact that all the early commentaries and early state decisions, 19th century state decisions, basically recognized that the people at large have the right. Of particular interest to me was the discussion of Reconstruction. The court cited a couple of my works, one of my books, Securing Civil Rights, on the history of the Black Codes, where the southern states banned any carrying of firearms by African Americans, either absolutely or only with discretionary permits. And that was one of the reasons for adoption of the 14th Amendment, was to get rid of that. I filed an amicus brief on behalf of Congress of Racial Equality, making the same point. Mm-hmm. And the court went into great detail on that. So on history, we win. Now, the court said it's unclear whether open carry could be banned constitutionally. It's not an issue here. But you have to allow some kind of carry, at least open or concealed, even with a permit. So the court doesn't dispute that you have to get a permit, but it should be available to all law-abiding people. And that's what the Second, Third, and Fourth Circuits totally ignored, that they think that law enforcement can decide who has the ability to exercise a fundamental constitutional right.
You know, and it's interesting, Steve, as you point out, and as the decision pointed out, the history of the right to keep and bear arms suggests that there's always been that right to bear arms. As the Ninth Circuit said, look, if California wanted to ban open carry or ban concealed carry while allowing the other, well, that'd be one thing. But you can't ban both. You can't deprive people of the ability to carry a firearm for self-defense in some form or fashion. I would, and again, I realize this isn't a legal a point, but I would say at that point, then you're kind of arguing over semantics. I mean, I would think the gun control advocates, their position really isn't, well, we prefer open to concealed carry or concealed carry to open carry. They don't like the carrying of firearms. So this was a major defeat for them.
Right. They're the same ones who argue that you don't even have a right to possess the gun in your home.
Exactly. Yeah, I mean, I realize they say they're completely pro-Second Amendment, and they're only in favor of, common sense gun safety reforms. But like having to lock your gun up unloaded and disassembled and not being able to use it for self-defense. Common sense stuff like that, right? Right.
I mean, they have value judgments that are adverse to the basic value judgment that's in the Second Amendment, which is it's in the Constitution, so it's off the table, to use Heller's words. You can't ban the right, and it might be controversial. Some people might not like it, but that's what we have, and there's no way around that unless you were to change the Constitution, which nobody wants that to take place. So what we're stuck with now is a circuit conflict, and now San Diego can go to the full Ninth Circuit and ask for a rehearing by the entire court, and I fully expect them to do that. And what would happen, whether it would be granted or not, would be yet to be seen. But the opinion it's really the most exhaustive opinion so far on this issue. It talks about the early 19th century court cases where there were actually states that tried to ban the carrying of guns, and they were stricken by the state courts at the time. And then the Supreme Court in Heller recited those cases when it talked about there's been few times in U.S. history where the bans were so extreme that courts had to strike them down like we're doing in this case, in the Heller case. And then it recalled those antebellum cases and basically said that these cases also are examples where unconstitutional statutes were passed banning the carrying of arms. So it's all, you don't have to read the tea leaves too carefully to see in the Heller decision itself, the court recognized the right to bear arms outside the home.
Yeah. No, absolutely. And in fact, it was, one of the things about this opinion, Steve, having seen the opinions coming in from the Second, Third, and Fourth Circuit that really, I think, went out of their way to dodge addressing some of these questions, relying on that language of Heller that says, nothing in this case should have any doubt on longstanding laws. It was really refreshing to see this opinion actually, again, examine the law, look at what Heller actually said, and the reasoning that went into Heller, and then applying that same reasoning to the denial of these concealed carry permits on the basis of self-defense. It was when you actually are able to look at these laws honestly, it's amazing really how clear the issues can become. Again, I'm so disappointed that the Second, Third, and Fourth Circuits haven't applied the same reasoning that we saw actually in Heller, that they've, I think, punted on these issues.
Well, now this is interesting. If you remember in the Heller decision, Justice Breyer filed a dissent where he advocated an interest balancing test. You look at the right and then you look at the government interest, and the government usually wins. Mm-hmm. This is otherwise known as intermediate scrutiny.
Right.
And these three circuits that have ruled adversely to the right apply what they call intermediate scrutiny, and they even use the word balance when they talk about that. You balance the right against the government interest, and that's exactly what the same word that Breyer had tried to use in the Heller dissent, the interest balancing, and that's exactly what the majority in Heller said is not appropriate. And the court in this case in Peruta didn't even see a need to go there to even talk about standards of review, because this was basically an absolute ban on the right, the same way that you had a ban on the right in the Heller case involving D.C.
Yeah, but there was a portion of the decision yesterday where they were, and I believe it was when Justice O'Scanlan was talking about the Second, Third, and Fourth Circuits and how they had given this deference to the legislature and there was almost this chiding of, y'all have given deference to the legislature, even in some cases where the legislature hasn't been able to provide any evidence to you that these laws actually serve the public interest.
Right. In fact, the court even said, even under this intermediate scrutiny test, this policy of the county cannot be sustained because the government interest is clear to reduce crime, things like that. But this, as a means to that, there's no evidence whatever in support of it. And basically it comes down to, why don't we limit the number of people who can exercise their constitutional right to bear arms? And that's supposed to serve the government interest of reduction of crime. Well, you know and I know we're talking about a small number of criminals who would never be issued a permit because they have criminal records and they have bad character.
Mm-hmm.
And those are not the people we're talking about here. In fact, the more people who are qualified, law-abiding people carrying arms, the less chance of crimes being committed exists anyway. So, I mean, that's just known from criminology. But this case doesn't depend on criminology. It has to do with the fact that when the Bill of Rights was adopted, this issue was settled, that the people have a right to bear arms, and that's what the court is upholding here.
Absolutely. Well, listen, Steve, you said you do anticipate that this will be appealed for an en banc review at the Ninth Circuit?
I would think so. There's a dissenting opinion.
Right.
And that, therefore, the county of San Diego their lawyers would rightfully think that maybe we could get enough judges to vote for an en banc rehearing and maybe even prevail at that level. So that's always possible. It does mean that this is going to drag on some more. It's obviously not going to be, the Supreme Court's not going to be asked to review it anytime soon, I don't think. We're going to have to get through the en banc stage and see whether there'll be further action in the Ninth Circuit, and then see what happens after that.
All right. Well, listen, I appreciate you coming on the program, and we'll keep our eyes on the Ninth Circuit Court of Appeals. But very exciting stuff, Steve.
Oh, it's a wonderful opinion. It's almost 70 pages long, but and I realize your listeners are mostly lay people, but if they would try to read it, I bet they would understand a lot of it, and would see what a wonderful opinion it is.
Listen, if I could understand it, I'm sure the audience can get it. So I absolutely. Steve, thank you so much, sir. We'll talk again soon.
Sounds good, Cam. Thank you for having me.
Steve Halbrook, Second Amendment